Did you know some states collect babies' blood and use it for whatever they want, including selling it to third parties and giving it to law enforcement? If you've ever had a child, you may remember medical staff pricking your child's heel to collect a blood sample and test it for disorders. Every state conducts this kind of testing. New Jersey, however, goes much further. It stores the blood for 23 years without the parent's consent or knowledge. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. And today we're talking with IJ attorneys Rob Fromer and Brian Morris. They recently teamed up with New Jersey parents to file a class action lawsuit challenging the state's unconstitutional retention of blood from every newborn in the state. This is Beyond the Brief. So, Rob, can you give us a bit of background on the program in New Jersey?
Absolutely. What's happening in New Jersey came to us as a shock to us. What we found out last summer was that law enforcement were going in and requesting blood to do criminal investigations without getting a warrant. And we did some digger deeping, and it turns out that New Jersey was testing children's blood, which is pretty understandable and common throughout the United States. But what they weren't telling parents is that they were holding on to the blood afterwards for up to 23 years and doing whatever they wanted to with it.
Brian, how does a normal program like this work? It isn't weird necessarily for, a family to go to a hospital, when the child is born, you stick the heel, whatever. That seems pretty normal. So how does this work in other states?
Yeah, so every state's a little bit different. So every baby that's born in America, its heel is pricked. They put some blood on the card, and then it goes off to get tested for diseases. Now, depending on where you live, it varies greatly what happens next. So a lot of states like Virginia and Alabama, they test for the blood for the 60 some odd diseases, and then if there's nothing wrong with it, they destroy the card within a couple months. That's probably the best case scenario. Then there's other states where somewhere in the middle where they'll, like New Jersey, they'll take the blood, they'll keep it for some length of time. They don't tell parents what they're doing with it, and there's no oversight on what they can do with it. So basically the state is keeping the blood in secret, and they can do whatever they want with it. Now, there's still some other states then that have some protections in place where they'll say, well, we'll keep the blood, but you can only use it for A, B, and C. But New Jersey's kind of the worst of the worst, where it just has no restrictions whatsoever.
If New Jersey isn't asking parents for consent, how did our clients find out about this? Because it seems like a practice that they're kind of keeping secret, but our clients became aware of it and reached out to us.
IJ found out about it through a public records request about a year ago, last summer, where there were some criminal investigations that they tied blood to a suspect, and everyone in New Jersey was kind of like, well, where's this blood coming from? And after some digging, and the state, New Jersey, opposed revealing anything, but after a court ordered them to, it was revealed that this database of the children's blood that they had been collecting, they had been giving it to law enforcement officers without a warrant. They'd been entering into agreements with outside public health agencies to turn over the blood. And that's where parents really kind of alarm bells went off, and we got involved.
So this is creepy. Obviously, it's, reflexively creepy. But what are the constitutional issues with the program?
Well, the biggest problem here is that New Jersey's program, its secret retention and use of this blood without getting parents' informed consent, violates a couple different parts of the Constitution. One is the Fourth Amendment. We have a right to be secure in our persons, including in our blood. And that means that if before the government takes it and keeps it and holds onto it to do what God knows what, they have to get our consent first. And the other important thing here is remember what's happening. These are babies, and their heels are being pricked, and this blood's being taken, and parents are never being given any oversight or any way to meaningfully decide what happens to that blood. And that violates parents' rights to, be parents, which has been protected for over a century by the Due Process Clause of the U.S. Constitution.
So when I first hear this case, I'm kind of drawn back to Henrietta Lacks, which of course is a famous 20th century example of a person whose cells were taken without her consent, ultimately used to create the groundbreaking medical treatment that's still used today. The California Supreme Court in that case, of course, ultimately held that the discarded cells from her body were not her property. So how are you trying to wrestle with this? How does this case stand distinguished from the Henrietta Lacks example?
Well, my understanding is that with Henrietta Lacks is that she was undergoing treatment for disease, and then it was a byproduct. That the blood cells were a byproduct. That's different than what we have here, where the government is intentionally taking this blood, the person's blood, and putting it to its own use. And in that situation, you can't argue that this blood is abandoned, because the only reason New Jersey has it in the first place is because it demanded it. And what that means under the Fourth Amendment is it has to get our consent before it does whatever it wants with it.
Does New Jersey even know what it wants to use the blood for? It seems like it's not telling parents what they're going to do, but it also seems like they kind of don't have a plan other than we'll keep it in a box and maybe one day something, ?
Well, I think New Jersey probably has a plan. They just don't want anybody to know it. So every state that there's been these lawsuits, there's this black box of, hey, we're going to keep this blood in secret so nobody knows, and we're not going to tell anybody what we're doing with it. And then once some light is shined on what they're doing, there's just some really egregious things that come out. In Texas, for example, they said they were doing nothing wrong, and it turned out they were turning the blood over to the Pentagon to create some national and hopefully one day international database, like a registry. And then other states have been caught selling it to third parties. So, today's day and age too, that with how valuable data is, and this is extremely personal data, it's very valuable to the state, and we would be shocked through discovery if we don't find out that there's even more abuses.
If New Jersey's program is unconstitutional, and it sounds like it is at first blush, what would a constitutional blood collecting program look like if any such program could exist under the law?
Well, I think that the gravamen of our complaint, like what we're focused on, is really the rights of parents and the rights to be informed about what uses blood's being used for, and to get consent. So I think that the biggest problem with New Jersey is it goes off the rails because it doesn't ask for that consent. So a constitutional program would tell parents, we want to use the blood for certain specific reasons, and we'd like your informed consent for that. And otherwise, if they don't get that consent, they have to destroy or get rid of that blood. Because after all, if I don't give you my permission, you're not allowed to have it.
And Texas has a good example of best practices where, parents get a card and they take the blood, and then the presumption is that you don't consent for retention. And then for the state to keep anything, there's different explanations on how they want to use it, maybe for medical research purposes, but only after they de-identify the blood. And parents can opt in to different things, or you can only keep the blood in case, God forbid, one day I need to use it to identify my child. But you can opt in after knowing full transparency on what the state's going to use it for.
So New Jersey has been using this for, criminal investigations and things like that. We found out about it because of that sort of thing. Is there a legitimate, government purpose there? Is it fair enough for New Jersey to say, hey, we're responsible for enforcing crimes and finding criminals, and, we get that there's a privacy concern here, but the need to catch bad guys outweighs this privacy concern? Is there anything to that?
Well, the Fourth Amendment's in the way. And, it's a big problem. I mean, police could solve a lot more crimes if, they showed up to kindergarten class and took blood and hair from every kid that went through the system, right? And kept a national database. But there's constitutional ways to investigate crimes, and there's unconstitutional ways. And this system is just ripe for abuse, and it's way beyond just the law enforcement concerns as well. I mean, the other thing is, just last week, 23andMe was hacked, and hackers got a ton of information, this highly private information from individuals who submitted their DNA. And there's like fraud concerns on you can sell that data, and then it's easier to, trick people into sending money, or you can sign up for, fake programs, all sorts of things.
Rob, you touched on this earlier, and Brian, you might want to add to this as well, but we're talking about this in the context of the Fourth Amendment. Typically, when you think of a Fourth Amendment challenge, you think of, police searched a home without a warrant, police seized my automobile, right? You very rarely think about it in the context of bodily autonomy, the right to your blood and your DNA. So I was wondering if one or both of you could spend a little bit more time unpacking that and maybe how it relates to IJ's broader project on the Fourth Amendment.
Absolutely. Well, at IJ, our project on the Fourth Amendment is attempting to secure our constitutional rights to be secure in our persons and property. And this concept of like owning yourself and being in control of yourself and being able to decide is a fundamental aspect of autonomy. After all, we all every day make a million choices about what we want to do, where we want to go, who we want to see. And that's all based on the idea that we have a right to decide for ourselves what kind of activities. Similarly, we have a right to be secure in our bodies. Just like someone couldn't kidnap me off a street and grab my yoink my kidney because they really needed it, they can't grab my blood because they think they might have a little bit more efficient policing. The Fourth Amendment stands there overwhelmingly to keep us secure from an overweening government presence.
So our lawsuit isn't challenging the initial, prick, right? It's dealing more with sort of the continued retention, or in some of IJ's other cases, I think we talk about this in the terms of, continued seizure. So how does that work? What does that even mean?
Well, the continued seizure doctrine is actually something that we're really interested in working up and developing more here at the Institute for Justice. This is an emerging area of the law that says that even after the government has taken something from you, it can only hold on to that thing so long as it has a justification. And once that justification disappears, it either has to get your permission to keep holding on to it or let it go. And this initially came up in the context of just, cars. People's cars would get towed, and in California, they would hold them for 30 days, even if you're willing to pay the money and get your car back. And the Ninth Circuit there said, you can't do that. Once the justification's over, you have to give people their cars back. And the exact same thing here. The government might have a justification for the initial stick, to test for diseases and all that. But once the testing is done, that justification ends. And at that point, the Fourth Amendment calculus changes dramatically and says, look, unless you get permission, you can't keep hold on to this.
Which it's just surprising. I mean, that doctrine seems pretty easy to understand, right? If the government has your stuff for reason A and that's over, and they want to keep it longer, they have to have a new reason. But the circuits are split on this, a pretty deep split, where the government has convinced a lot of courts to say, well, as long as we had the original reason for taking it was okay, and even if that vanishes, we still got to keep it. I mean, it's happened in the context of, they may seize somebody's property, a victim in a investigation. It could be a victim's car. There was one case where a car was shot. Guy wasn't involved in the crime at all. He wanted to get his car back after the investigation was over, and they said, you know what, we're going to hold on to it for a 30-day period, and every 30 days we're going to charge you some money. Yes, and there's other cases about inmates being in jail and they'll be released, and they have they've taken inventory over all of the things that they had in their possession when they came into jail, and sometimes the jail says, well, we're not going to give this particular property back, and we like to keep this one, and some courts have said that's okay.
Yeah, we've actually signed on to an amicus brief before the D.C. Circuit, that's the second highest court here in the country, about exactly this. There was some protesters who got arrested during 2020, and they got out, but the police decided just to keep their cell phones forever, no justification. And now the D.C. Circuit's saying, does that comply with the Fourth Amendment or not?
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
Both of you just talked about, ongoing cases involving the Fourth Amendment generally, but are there any cases specific to this type of blood retention policy that you guys have seen? Because, it sounds like this practice is widespread. It sounds like New Jersey's is maybe a whole standard deviation worse than what some other states are doing. But have there been other challenges in federal court to these types of policies? And if so, how did those pan out?
There's an ongoing one that's on appeal in the Sixth Circuit from Michigan currently, which was brought by a dad who happened to be an attorney and was shocked to hear that Michigan at the time was keeping kids' blood for 100 years, so for the whole life of the child. And he sued them, and he won below. They said that violates the Fourth Amendment and his rights as a parent, and that's currently on appeal in the Sixth Circuit, which the government there in their briefs said, we've done nothing wrong. This is totally okay. You have no interest in this. We get to do it. We don't even have to tell you about it. So we're...
What was the phrase they used? This is a paragon of good government.
Yes, this is
stealing your blood and using it for God knows what. It's the paragon of good government.
Yes, that was
That's quite the oversell.
that was the first line of the brief. This is good government, just the best it gets.
Wow. To not even say, oh, this is fine and you should let us do it, but this is not only fine, but it's, exemplary. That's absolutely ridiculous. A random detail question. Michigan keeping it for 100 years almost makes more sense to me than what New Jersey is doing, because New Jersey's keeping it for 23 years, which feels sort of arbitrary a little bit. Where did that come from?
Well, I think it shows how just really arbitrary and lack of oversight this entire system is, right? There's no statute or regulation in New Jersey that's telling the health department, you get to keep this blood, right? There's nothing. There's no oversight whatsoever. There's also no statute that says you have to destroy it. So someone in the health department decided along the way, hey, what are we going to do with this blood? I guess we could keep it and put it in a state-run facility and use it however we want. And there's nothing telling us that we can't. And then the 23 years ended up, New Jersey, like buried deep in their administrative code, has a retention schedule for different types of things that it keeps. And this, for whatever reason, got lumped into 23 years as one of their standard buckets of time. So it just is another thing that they're keeping it's just buried on some bureaucrat decided, this falls into this type of category, we get to keep it. And so that's the 23 years.
Yeah, so just a blip of, bureaucratic eccentricity. Yes. Yep. How bizarre. Yeah.
This is more of a straightforward question. I'm curious about the clients in this case and their motivation for getting on board with this lawsuit, because as we all know, lawsuits can be challenging. They involve a lot of time. What's motivating IJ's clients in this case to step up and challenge New Jersey's blood collection program?
I think Erica and Hannah are just unbelievable clients. And I never thought I could get more excited about this case until I met them. And they're both in it for totally the right reasons. They care about their kids, they care about New Jersey, and they want to protect families. Hannah was describing a situation where, she had a long road to pregnancy. She's sitting there in the hospital and she's like, I think everybody here is here for the right reasons, right? We care about having a healthy baby, my health in the hospital, and you think your doctors, your nurses, your family, everyone in that room is there for just making sure that that baby's okay. And it's kind of this magical moment that's, most parents will say it's one of the key moments in their life is that day. And she goes, to know now that in that moment, the state was reaching in and taking a part of your baby that you're tasked with protecting, and you've already failed from day one because the state has come in and taken part of your kid and kept it in secret, and there's nothing you can do about it. You don't know where the blood is. You don't know what they're doing with it. And that's just like, from a parent's perspective, just like to your core is really hard to swallow and feels really, Hannah and Erica use words like appalling and distressful a lot because that's, and hopeless, it's kind of, what are we supposed to do? And Erica said the same thing. She hopes that she raises her boy, that he never has a run-in with the law, right? We all hope that as parents, but you never know. You never know in 20 years what technology will allow this New Jersey to do with this blood, or whose hands it could end up in, or how it could come back to hurt their kids.
So, Brian, as a parent yourself, does this, finding out about this, does it change anything about how you're thinking about, taking your own kids to the hospital, kind of going through this process as a parent?
Yeah, when we found out, when Rob and I started this case, my wife was pregnant with our second boy. And so I did some digging myself. In Virginia, where our son was born, thankfully, Virginia is one of the better states where, I talked to the nurses after my wife gave birth. I think my wife was
totally normal interaction.
My wife was rolling her eyes like, you're bringing this up now. But it also shows like the healthcare workers themselves often don't know about this, right? They were just as shocked as I think parents to learn what's going on with what the state does with it, because I think they are there for the right reasons and trying to protect these kids. But Virginia is one of the better states where they actually, one of the reasons that some states say they need this blood is if something terrible happens and we need to identify your kid, we have their blood to identify them. Virginia only keeps the blood for 6 months to a year. As soon as they realize that all the results are normal, they destroy it. But they actually give parents a little droplet of your child's own blood that you can take home with you. So it's actually our second son, his blood's sitting in my safe at home, and they actually let you take it home. So that alleviates some of the concerns that the state may have, allegedly, is, hey, well, if we need this, then we'll give it to the parents to take care of, right? The parents can possess it and understand and know what to do with it. And then for my first son, I looked up Ohio's law. He was born in Ohio, and they may be on our list because it's a little iffy about what they do with it. But that's what a lot of states kind of hide it so that parents kind of don't know what to do.
Well, speaking of that, I'm sure a lot of parents watching this and listening to this are finding out about these programs for the first time. Is there any way that they can go online and find out what their state is doing? Because it sounds like you might have to be a lawyer to dig into the code and figure out what they're requiring. But do states ever, advertise this publicly? Or is there any way that parents listening can see what happened in their state?
There are ways. You can. There's like babyfirst.org is a website. But then IJ, we're also putting together a kind of a 50-state grading system where we're going to give states, California might get an F and Virginia may have an A. But we're putting that together as well so that parents can have easy access to that. And legislators as well. We've gotten a lot of calls from, elected officials across the country who have seen this, and they're learning about it for the first time as well and wanting to know how to make sure to protect families in their home states as well.
It's kind of wild that, elected officials who are responsible for, making and enforcing the law would themselves be completely in the dark about this kind of law existing. How does that, is it just that it's existed for so long and nobody remembers it? Somebody had to have,
I think Brian explained it well, that it sort of fell in the gaps. It wasn't authorized, but it wasn't prohibited. So that meant the agency on its own could decide to do what it wanted without having to advise or get anyone's permission. That's how this exists, because one bureaucrat in Trenton decided untold years ago, hey, let's create a database. Nothing says we can't.
Yeah, and some states, I think Rob's exactly right. It fell through the cracks, I think, in a lot of states. These testing has been around since the late 60s, early 70s. So a lot of the legislation was drafted back then, and then things haven't really been updated. And then some states, Utah is one of the worst, I think, as well, where it actually says, it mandates it, you have to give us your blood for this testing. And then it says, well, as soon as the state has possession of the blood, it is now the property of the state. So we've been speaking with some people out there to try to get that change as well. So it's kind of, as with anything, if it's 50 states, it's kind of a shatter shot all over the place.
Rob, you mentioned that a bureaucrat kind of decided to do this of their own volition in the sense that nothing in the law prohibited the agency from doing so. At the risk of getting maybe too far in the weeds here legally, that rings a little bit to me like a delegation problem, right? The fact that the legislature didn't affirmatively give this agency the power to collect and retain babies' blood for 23 years Is that a part of this case, or are we really only focused on the Fourth Amendment constitutional challenge?
Well, you raise a very interesting point. The delegation here is a palpable concern, and we often see that the size and scope of government grows because there's no check, no permission you have to get before you expand it a bit more. But we're focused here on the core constitutional issues of parents' rights, parents and children's rights to really be secure in their own bodies, and that parents, not the state, gets to decide what happens to their children.
So you were talking earlier about how, all 50 states sort of handle this differently. Do we have any idea if, things are mostly on the okay side or mostly on the, bad New Jersey side?
I mean, I would probably ballpark think of it in thirds. There's a third of the states that seem to do a pretty good job, a third of the states that are kind of in the middle. There's some states where they'll ask for informed consent, or maybe they won't ask for informed consent, but there's lots of restrictions on how the state can actually use the blood. And to be constitutionally sufficient, we think they still have to ask permission. So there's probably a third in the middle bucket, and then a third on the New Jersey, kind of California, Michigan end they just keep it for a really long time and do whatever they want.
But we'll have more details once our report comes out.
For our listeners who maybe aren't parents, why should they feel concerned, right? There's almost a sense that, this is really about parents and children, and some out there might think, well, I don't have any kids, I'm 35 years old or however old, and therefore my blood isn't being retained. Why should I care about this?
Well, I think you care about it because the Fourth Amendment issue here really applies to everyone. I know we're talking about babies and parents, but if you're not secure in your person, in your medical information, things that you share with your doctor, how are you going to live your life? How are you going to be able to go get the new goods and services? How are you going to function in a modern society when you constantly have to look over your back thinking that the government's hoovering up all your data to use it against you? That's why we're focused on this, because in order to chart your own path in life, you have to be secure. And that's why the founders created the Fourth Amendment.
Yeah, I think with people who aren't parents still, I think, as technology advances and you can, have genetic mapping and things like that, right? There's really a lot of sensitive information that third parties or the government can get about you if they have your blood. And I would link it to the same kind of growing concerns we have for digital privacy as well. If we don't kind of draw a line in the sand here and say the Fourth Amendment protects digital privacy, genetic privacy, and have robust protections now, it's only going to get more and more invasive as technology grows.
So, if we prevail in this case, what does that mean for people in New Jersey and throughout the country?
Well, for New Jersey, it means, we brought a class action lawsuit. So it means that we will protect every child and parent in the state. They will get rid of the blood, or there are two things. They either have to get parental consent to keep or retain any of the blood, or it's destroyed. So it'll protect families across New Jersey and create robust protections under the Fourth Amendment. And then, IJ, as we've talked about at length, this isn't the only state that there's a problem. So we'll use this as a springboard to work our way through kind of more egregious states and make sure that this precedent applies to parents across the United States.
Well, thanks so much for coming and talking to us today about this case, Brian and Rob, and we're really enjoyed the conversation.
Thank you. Thanks for having me.